Welcome to The Explainer. All right, if you're prepping for the bar exams, we're going to talk about an absolutely critical tool in your advocacy kit, the interlocutory injunction. We are going to break down exactly how you secure one, step by step, using the key authorities you just have to know.
Okay, let's dive in. Picture this classic bar exam scenario, right? The damage is imminent, money is not going to fix it, and the clock is ticking. What's your move? It's an interlocutory injunction. You have to convince the court to hit that judicial pause button, and you have to do it fast. So, this is the remedy we're mastering today. Now, as it's laid out in Section 14-150 of the source material, its whole job is to just hold the line until trial. And remember, this is different from a short-term interim injunction you'd get for an absolute emergency, or a perpetual injunction, which is final. We are operating in that really crucial middle ground.
So how do you persuade the court? Well, it all comes down to the definitive two-limb test from the High Court's decision in Beecham Group, and you'll find this in Section 14-160. You should basically get this next part tattooed on your brain for the exams. First, you establish a prima facie case, and second, you prove the balance of convenience. Limb 1, the prima facie case. That's your ticket in the door. You have to show a sufficient likelihood of success at the final trial. Look, the court isn't running a mini-trial here. It just needs to be satisfied that your claim isn't frivolous and that it has a real probability of getting up down the line.
Now pay close attention, because this is a classic exam trap, and it's also covered in Section 14-16. In Australia, we follow the stricter Beecham test. That means we require a probability of success. This is a much higher bar than the UK's American Siamate approach, which only requires a serious question to be tried. Whatever you do not confuse the two in your exam.
Okay, so once you've cleared that first hurdle, you move to the second and honestly often the most decisive limb of the test, the balance of convenience. This is where your advocacy skills really have to shine, because you're no longer just arguing the law, you are weighing pure risk. And this is the core question, drawn directly from Section 14-180. The court is, quite literally, weighing the potential harm to both sides on a set of scales. Your job, as the advocate, is to prove that those scales tip decisively in your client's favor.
So as outlined in Section 14-180, the court is looking at these competing risks. For your client, you're going to be arguing irreparable harm. Things like lost goodwill or a unique opportunity that money just can't replace. Meanwhile, the defendant will be countering with arguments about business disruption and financial loss. Your entire job is to persuade the court that the harm to your client from inaction is far, far greater. But within that whole balancing act, there is one question that really stands above all the others. This is the number one point from Section 14-190 that you absolutely have to address, and that is an award of damages an adequate remedy? Because if money can truly fix the problem for your client, the court will almost always refuse the injunction. Your critical task is to prove why, in this specific case, it can't. Now, another key factor in this whole balance is preserving the status quo. But as Section 14-170 explains, this isn't always what you might think. It's often the state of affairs before the wrongful conduct even began. The Walsh case is a perfect example. The court there preserved the employment relationship as it existed before the dismissal, not after it happened.
Okay, so now that we have the main test down, let's turn to two special, really high-stakes scenarios where the rules become even more demanding: the quia timet injunction and the ex parte application.
First up is the quia timet injunction, and you can find the detail in Section 14-200. It's Latin for because he fears, and it is your preemptive strike. You use it when you can prove a defendant is about to commit a wrong, and you have to show a very real risk of imminent and significant injury.
Second is the ex parte application, which you'll find in Section 14-210. This is for true red alert emergencies where you appear before a judge without the other side even knowing you're there. Urgency is absolutely everything here. You use this incredible power when giving notice would just allow the defendant to shred evidence or completely defeat the purpose of the injunction.
But with this great power comes an immense responsibility: the duty of full and frank disclosure, also from Section 14-210. Because the other side isn't there to tell their story, you have an ethical obligation to tell it for them. You have to present all the relevant facts to the judge, especially the ones that are unfavorable to your own case.
And make no mistake, the penalty for failing this duty is severe. As the court made crystal clear in Grant-Matic & Co., the injunction will be dissolved, no questions asked, your application will fail, and your professional credibility with the court will be in tatters.
You know, in the end, an interlocutory injunction is a discretionary remedy. Knowing the Beecham test, that's only half the battle. Your real job as an advocate is to marshal the facts and persuade the court to exercise that discretion. The framework is yours. Now go make the argument.